Okay, I'm a little sad because part of me, I'm elated, right? Summer A is almost over. I'm off summer B. Even though I got nowhere to go with the pandemic, but hopefully, who knows, things will work out for the best. But I do want to do a wrap up video, not just for Module 6, but for what we've done this entire semester. Just because I think it's important. You just can't, I don't want to leave you hanging on a thread, right? I want you to give you a proper finale, proper conclusion to the course. Week 1, all I did, Module 1, I introduced you to the most craziest group of people I've ever seen in my life, right? The Tiger King industry, right? The Tiger King documentary and the big cat industry. Just what a remarkable group of people, right? And what a remarkable, beautiful group of animals, right? That they interact with on a daily basis. I'm going to be honest with you. I find Tiger King to be just poetry. Just a beautiful, beautiful show. So week 1, I took my foot off the gas, let all of you watch or rewatch, write about Tiger King, and I also kind of introduced a subtle difficulty here in asking everyone to choose, hey, are you more with Joe Exotic or are you more with Carol Baskin? Just to show you, right? I mean, sometimes life is full of these types of difficult choices. Module 2, big picture sources of law. Really, when we talk about the law, we should really be talking about the laws or systems of law, right? We have all the way at the top international law, the law of nations, private and public international law, treaties, etc. We saw that, when we look at public international law and treaty law, right, each government or each state decides, which treaties it wants to comply with. We saw that's kind of interesting. Then on the domestic side of law, when we look specifically at the USA, we saw we have 2 levels of government. So we have 2 levels of law, state law and federal law. Now, you could say we have 3 levels. We have local law, but legally speaking, local law is a subset of state law. It's up to the state legislature to authorize, delegate some of its powers. Like, for example, in Florida, right? At the county level, counties have certain powers to enact local ordinances, but those powers are granted by the state legislature. So we really could just narrow it down to state law and federal law. And then we saw this in the context of animal rights and animal law. We saw, for example, Florida's animal cruelty law, and we saw federal law. We saw the Endangered Species Act. We saw a new law that was just enacted, a federal animal cruelty law. And we even saw a pending bill, right? The Big Cat Public Safety Act. So we saw a lot there. Week 3, Module 3, we drilled down on something very unique to our legal environment in the USA. Often it's called Anglo-American legal tradition. It is the common law. It's called Anglo-American because it originates in medieval England. Actually, if we go further back, we could go back to ancient Roman law. But the point is, this common law, it's judge-made law. And judges have elaborated some principles and some doctrines that, when taken all together, add up to these, 3 major bodies of law: torts, accident law; property rights, property law; and promises, right, contract law. And so I just wanted to introduce you to something called the common law. And common law, because it's judge-made law, introduces a lot of complexity into the system, right? It's very decentralized. It's why lawyers are, so valuable in that they have to figure out what the common law is in each state. All right, week 4, I drilled down on what I call the law of ideas or intellectual property rights. And the reason why I did that is because IP, or intellectual property, it's a really important area of law if you want to create a business, grow a business, or expand a business, existing business. Whatever size your business is, one way of adding value to that business is by creating your own intellectual property or acquiring intellectual property rights from others. And you may recall there, what I decided to do is, we were halfway through the semester, I threw in a lot of videos by lawyer Aidan Durham, used to be Aidan Kramer, because first of all, I love her videos. I think they're really, really good, much better than mine, by the way. But also because she's a real expert, and we focused a lot on trademark laws because I know many of my students are marketing majors, and legally speaking, when we talk about branding, what we're talking about is creating a distinct or arbitrary or fanciful mark or brand to go with the company or its products and services. Then last week, module 5, right? We talked about, this is Tiger King, right? Civil and criminal cases. So we saw a civil case. One of the reasons why Joe Exotic and Carol Baskin, even though they hate each other, right? I mean, even though they are mortal enemies, they settled their case. That case, that trademark and copyright infringement cases never went to a jury. And we saw why in this course. Going to a jury is really not just expensive and time consuming, it's also highly dangerous. It's really uncertain. Very few people are willing to take their chances with a jury. And so Carol Baskin and Joe Exotic settled their cases. Now, one of the developments that happened right at that time was that because Joe Exotic tried to get out of the settlement through some shady, fraudulent transfers, the court gave this extraordinary equitable remedy, not just a legal remedy of money, but an equitable remedy of property rights, giving full control to Big Cat Rescue of Joe Exotic's former zoo. So we'll see what happens there. And then we saw also criminal cases. We saw the criminal charges against Joe Exotic. I included the original indictment, murder for hire. We saw some of the lingering allegations involving Carol Baskin and the disappearance of Don Lewis. But more importantly, we saw what all civil and criminal suspects and civil litigants have in common. That is the right to due process of law, the right to be treated fairly, the right to be heard and defend yourself. And part of the due process tradition is the burden of proof. The burden of proof goes on the party making the allegation. I should also clarify, by the way, if you're a defendant and you're asserting a defense, like self-defense in a criminal case or assumption of risk in a tort case, then of course you will have the burden of proof as to that defense. So whenever you make an argument, either accusing someone of misconduct or asserting a defense, that party has the burden of proof, of proving the truth of its, allegations or of its defense. Now, we saw the burden of proof varies. Criminal cases, of course, it's proof beyond a reasonable doubt. But interestingly, in civil cases, it's lower. It's just preponderance of the evidence. And notice, this is another big reason why the common law tradition is so important. None of this stuff is in the Constitution. I mean, due process is, but not burden of proof. Burden of proof is common law. It's judge-made. And so that shows you how the vitality of the common law, even in our current times. Finally, in Module 6 this week, we saw law and ethics. We saw, the relationship between law and ethics. I began with natural law. And even in our country, whether we're talking about the Declaration of Independence or MLK's letter from the Birmingham jail, we have or human rights law writ large on the international stage, right? The idea people have God-given or inalienable or human rights is a very powerful one. Then we looked at several major theories of ethics, whether it's virtue ethics, duty ethics, or consequentialism, and we applied these theories in the domain of animal rights. What is the moral status of animals? And we saw that, wow, it's actually interesting when you see moral theories play out like in the context of animal rights. I don't know, it just illuminates how you see the world and how you see right and wrong. And then finally, we ended the course with business ethics. And what I did there is, it may not sound like a lot, but we actually covered the two big, I call them the big two, Friedman doctrine, maximize profits, and corporate social responsibility, stakeholder theory. I should say both the Friedman doctrine and stakeholder theory are just two competing versions of CSR, of corporate social responsibility, right? And we tried, we identified strengths and weaknesses in both theories, and we left it at that. So with that, I want to say, even though it was a 6-week course, we actually ended up covering, I believe, a lot of stuff, and I want to wish you the best of success. in the rest of your college career. And please, stay in touch. And good luck to you, Godspeed, and charge on.